This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why an adjuster may not be sued to defeat federal jurisdiction and why a one-year private limitation action of provision is enforceable, at least in Pennsylvania and in most states. When a barn roof collapsed and suit was filed in state court in Pennsylvania to avoid federal court, they named the adjuster as a defendant, only to have State Farm move to remove the case to federal court, and the federal court refused to remand because the adjuster was not an appropriate party to the suit. In a case entitled Funaro versus State Farm Fire and Casualty, the United States District Court for the Western District of Pennsylvania, through Judge W. Scott Hardy, on November 19, 2025, found itself faced with motions by Plaintiff Funaro, including a motion to remand back to state court, State Farm's partial motion to dismiss, and a claim of statutory bad faith against State Farm alone. On January 10, 2021, a large barn roof in Honesdale, Pennsylvania, collapsed under weight of snow. The barn incurred structural damage, contents damage, including $90,000 to $100,000 in a custom French stove. Plaintiffs were insured under State Farm policy using a standard homeowner/farmowner form. State Farm accepted coverage and made payments of $40,000 for the barn and $35,000 for the stove. Plaintiffs obtained higher estimates, $225,000, and demanded additional payment by use of appraisal proceedings. Adjuster T.J. Ortman, a Pennsylvania resident, refused appraisal, citing the policy's one-year suit limitation clause had expired. Plaintiffs sued in Allegheny County Common Pleas on December 3, 2024, almost 4 years post-loss, and State Farm removed, asserting fraudulent joinder of Ortman to destroy diversity. The policy provisions at issue included the suit limitation clause, which states that no action will be brought against us unless there has been full compliance with all of the policy provisions. Any action by any party must be started within 1 year after the date of loss or damage, close quote. The district court noted that the quoted language is standard State Farm language and has been repeatedly upheld as reasonable under Pennsylvania law. The court's holdings included, first, dealing with the fraudulent joinder statute and standards, and concluded that there was no colorable or reasonable basis in fact or law for claim against a non-diverse defendant. Claiming tortious interference with contract against the insurer's adjuster is not colorable under Pennsylvania law when the adjuster acts within the scope of his authority. Since the adjuster as an agent of State Farm enjoys a qualified privilege, the adjuster was found to be fraudulently joined. The court then dealt with Count 1, specific performance, and Count 3, breach of contract. The district court dismissed both with prejudice as time-barred. 1-year suit limitation clause is enforceable and reasonable under Pennsylvania law. The court also found no estoppel because there was no affirmative misleading conduct by State Farm that prevented timely filing, and there is no evidence that the clause was unconscionable. Next, count 2, statutory bad faith against Ortman, was dismissed with prejudice because Section 8371 applies only to insurers, not adjusters. Count 4, tortious interference against Ortman, was dismissed with prejudice for the same reasoning as the finding of fraudulent joinder. Pennsylvania insureds generally cannot sue individual adjusters for tortious interference when the adjuster is acting for the insurer. The court then concluded that only Section 8371 bad faith claim against State Farm survived, while the court concluded that State Farm's 1-year suit limitation provision remains bulletproof. Individual adjusters are effectively immune to tortious interference claims in routine disputes, and only the bad faith claim versus State Farm proceeds with appraisal possibly available as a remedy thereunder. In my opinion, for reasons known only to policyholder attorneys, the preference for suing an insurer for bad faith conduct in state court. They will name the adjuster to defeat diversity and remain in state court. Since an adjuster is just acting as an agent of the insurer, the adjuster cannot be a proper defendant. The court only ruled on the motions before it, and the remaining cause of action, bad faith, appears to be subject to the 1-year private limitation of action provision and will probably be the subject of a new motion for summary judgment by State Farm. This activity of joining adjusters and lawyers is not new. More than 40 years ago, I would be named as a defendant in bad faith lawsuits because I wrote a letter for a client explaining why their claim was denied. Those lawsuits would eventually be dismissed because it was a proper joinder, but it caused a lot of headache for me and for many adjusters who were also being sued to avoid federal court. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about these blogs and these videos on rumble.com and youtube.com so that they too can subscribe. They're free. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.